Hello again, my lawyer friends. Rule 1.3 is simultaneously a simple and complicated rule. Rule 1.3 is titled Diligence. It says a lawyer shall not intentionally, repeatedly, recklessly, or with gross negligence fail to act with reasonable diligence in representing a client. Seems simple? Well, it's a little more complicated. Keep watching to learn about your responsibility to remain diligent in representing a client. I will also give a practice tip towards the end that will not only help you avoid discipline, but it will also help you get better results for your clients. And don't forget to subscribe. Rule 1.3 requires reasonable diligence in representing a client. But it only requires that you do not intentionally, repeatedly, recklessly, or with gross negligence fail to act with reasonable diligence. If you have watched this series in order, you will recognize that language because Rule 1.1 regarding competence uses the exact standard, although in a different order. In fact, the comments refer to Rule 1.1 because diligence and competence are different requirements. And like Rule 1.1, this seems to mean that an attorney who fails to act with reasonable diligence only once or with ordinary negligence does not violate this rule. The rule also defines reasonable diligence, but it's a pretty vague definition. It says that reasonable diligence is acting with commitment and dedication to the interests of the client and not neglecting, disregarding, or unduly delaying a legal matter. The comments to this rule clarify that this is only regarding a lawyer's own diligence, and Rules 5.1 and 5.3 deal with a lawyer's responsibility in overseeing other lawyers or non-lawyer staff. So you can see why something that otherwise seems so simple is really not that simple. So what are you supposed to do? Here's the practice tip. Don't procrastinate. I know it seems obvious, but a lot of lawyers postpone research or retaining an expert or conducting discovery or beginning trial preparation. And the reason they delay is because cases usually settle, and they don't want to do unnecessary work, either because they don't want to waste their own time or they don't want to unnecessarily bill their clients. And these are good reasons to delay. But what you will find is that a lot of that work, if you do it early, will pay off with big dividends in the long run. It will save you time, and it will save your client money, and it will get you better results because you will be prepared. And the fact that there has to be a rule that says that lawyers have to be diligent seems to indicate that a concerning amount of the procrastination ends up hurting clients. That means that lawyers with good intent, such as saving their clients' money, are ending up disciplined because of an error in judgment. On the other hand, you never want to overwork a case. And that balance between being diligent and also not overworking the case is an important skill and an important judgment for you to develop.